The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Good morning. The court is ready to hear argument in 19787, L Marketing versus Integrity Global Security from Travis County and the Third Court of Appeals District.
May it please the court, Mr. Danford will present an argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. Good morning and Happy New Year. I'm actually here on the Petitto case, which is an expunction.
Oh, I'm sorry. I misunounced it. Yes, 1910-51, ex parte Petitto. I'm sorry, Mr. Danford. Thank you.
No worries, Your Honor. Good morning again and Happy New Year. It's my honor to be here today. Quoting from previous cases, the expunction statutes have never been a model of clarity, but that's why we're here today, is to ask this court to give guidance to the other courts and make them clear. With the enactment of a statute and construing a statute, the government code teaches us in 311.021 that all statutes should have a just and reasonable result, and that's what it's expected. And that's what we're asking the court today to do in interpreting the Code of Criminal Procedure in Chapter 55.01A2, especially regarding this pretrial diversion that's before the court with this expunction. In reading Chapter 55 as a whole, different parts of the statute totally address different factual scenarios, from pretrial diversions to veterans court completions to acquittals and so forth. It's our position that the Fourth Court erred in taking the all or nothing approach. I have 4 points that I want to make clear with the court today, beginning with point 1. Under 55.01A2, a person, the petitioner, is entitled to expunction if they were arrested. In this case, it was for a misdemeanor. They were released. There was no final conviction. The case is no longer pending. There was no court-ordered probation or community supervision under Chapter 42 of the Code of Criminal Procedure. And specifically, they completed a PTI, a pretrial diversion, as is allowed by the government code.
Mr. Danford, may I ask you,
Yes,
it seems that this case has pretty much been decided under TSN, which we decided a couple of years ago, largely because of the terminology, the offense and the charge. Does the fact that that these two offenses were dealt with in the same plea bargain, does that affect the analysis?
Well, Your Honor, we're asking you to take the same position you took in TSN in subsection 1 of 5501 when you adopted the offense-based approach instead of the arrest-based approach. And I think the problem occurs in Chapter 5501A2 when you get to the exception, and that throws the chink in the armor. And if you let me explain, I think it will answer that question clearly. It says in that exception, you may not get an expunction if there was another offense arose out of the same criminal episode.
Mm-hmm.
And the kicker, and I think the most important part here was, and that person was convicted, and the person remained subject to prosecution for at least one other offense arising out of the same criminal episode. And the confusion, I think, with the courts of appeals comes in when we look at this same criminal episode. And I think if the court takes the offense-based approach that they took at TSN, then there will be no confusion for the courts of appeals. And the reason I say that is this. In Ex parte Ferris, the court out of Dallas says you don't need to take such a narrow view when you look at a single criminal episode. And in dealing with that, if you look at the definition in 3.01 of the Code of the Penal Code, it talks about same transaction, two or more transactions, or as common scheme, or related offense. But all the courts, well, not all the courts, but a lot of the courts want to take this arrest-based approach instead of the offense-based approach. And if you look at the facts in our case, the petitioner was arrested for a DWI. He was on his way to the jail because they were going to do a blood warrant. He was there, and then a subsequent officer was inventorying the car and found marijuana in his backpack.
Excuse me, was that the same day, or was that when they were doing an inspection of the vehicle?
It was
later?
the same. It was the same day, Your Honor, but it was like not at the same moment. So he was arrested for the DWI. He was being transported to the jail, and then an officer was doing an inventory and found marijuana in the backpack. But the DWI and POM are not related offenses. They're not lesser included offenses of any form or fashion. But then if you look at the same transaction, I don't believe they are, because in the DWI, when they arrested him, they never smelled marijuana. They never suspected he was on marijuana. They didn't arrest him based on marijuana. They arrested him based on DWI, and he was prosecuted for that DWI under a blood test with an alcohol limit over the limit.
Mr. Danford?
Yes?
What does it mean for purposes of our analysis here for an offense to be part of a criminal episode? Are there lines that are drawn, and how are they relevant here?
Well,
I don't see them as being part of the same criminal episode, but maybe you can help out there.
I don't believe they are part of the same criminal episode. I believe there were two separate arrests, and that's why I asked you to take the offense-based approach. He was arrested for DWI, and then subsequently he was arrested for possession of marijuana. And if you take that approach and you apply that subsection C where the exception is, he wasn't convicted of the possession of marijuana. There were no other charges relating to this arrest that were still pending or that he could be prosecuted for. So I think if you take TS.
So, Mr. Danford, under capital A of 5501A2, it talks about an information charging the person with a commission of a misdemeanor arising out of the same transaction, and I understand your argument there, for which the person was arrested and that it has not been presented against the person at any time. So both informations in this case were presented, right? So why doesn't that exception apply?
Well, he wasn't convicted of the other offense.
So under capital A, it requires a conviction.
Well, it's
or just the presentation of the information.
Well, if you look at the exceptions, it says that the charge was no longer that he may not get an expunction if there was another offense that rose out of the same criminal episode and the person was convicted and the person remains subject to prosecution for at least another offense that arose out of the same criminal episode. He wasn't subject and he wasn't convicted, and there was no other charges pending. All the charges.
So I understand that there was no conviction for the first offense, the one that we're in, but it looks like the exception then goes on to say if there's another offense that was presented out of the same transaction for which the person was arrested, where does it say that offense has to result in a conviction as opposed to there being an information for another offense?
Well, Your Honor, that's why we're asking you to take the offense-based approach to this as you did in subsection 1, because we believe there were two separate offenses. We dealt with one, it was non-disclosed. The code clearly says that if you complete a pretrial diversion, you're entitled to an expunction, and that's what we're asking the court to do today, Your Honor. But getting back to my points, we're asking the court again to adopt this offense-based approach when you're dealing with chapter 55.01A2. And this is why, because you did it in TSN, and then all the other courts have looked at that, and some courts in Dallas are applying it, some aren't, some in Houston are, some aren't, the El Paso Court of Appeals, the San Antonio Court of Appeals. They're all over the roadmap. But if you take this offense-based approach, as you did in TSN, number one, we'll do exactly what the government code tells us will result in a just and reasoned result, and we want the statute to give us just and reasonable results. But if you look at the legislative intent of A2, it was amended in 2011, and I believe Justice Alvarez in her dissenting opinion from San Antonio was correctly on point. But in that when A2, this is the way it reads today. A person entitled to expunge all records and files relating to an arrest, not arrest, it's not plural. If released, the charge did not result in a conviction, it's no longer pending, and there are no court-ordered community supervision for the offense. But back in 2011, it said, the former version said, for the offenses. And so it was changed in 2011, and I believe the legislative intent did that so this could be an offense-based approach. If you don't do it that way, then you're going to lead to these absurd results. And what I mean by that is the courts are not going to be able to, when you have multiple offenses, as you did in TSN, where one is clearly expungible and one is not, it's the same as we have here. The code says if you complete a pretrial diversion, you're entitled to an expunction. So that's why we're asking the court.
So, counsel?
Yes, Your Honor.
Practically speaking, when you have one arrest leading to two offenses, and only one of the offenses is expunged under the offense-based approach, what is it that's being expunged? Because the statute says you expunge records relating to the arrest, but if the arrest led to both offenses, can you expunge records related to the arrest for one offense but not the other, since the records relating to the arrest relate to both offenses? How does that work practically?
Well, I believe you can, and that's one of the points that the Department of Public Safety likes to make. It's too hard for us to figure out what we have to redact and not redact, but that's what happened in TSN. But our case is even more distinguishable or interesting on the basis of this. The other offense was non-disclosed. We had gotten a petition.
So if I could stop you there before you get to non-disclosure, your answer is that the government will keep the arrest record, but redact the portions of it that refer to the offense that's been expunged. Is that your understanding of how it would work?
That's my understanding, Your Honor. The Department of Public Safety, they're employees of the state of Texas and servants of our citizens, and they think it's a big problem to do this redaction. But in TSN and in other cases, they've had to do it. So I don't think it's that big of a problem, but that's how you would solve that problem. Moving on to my third point is about the non-disclosure. And I really don't think you ever even have to get to this part of the case. But just to clear it up, I agree with Justice Rodriguez again, or Justice Alvarez in her, it's actually in the dissenting opinion, that Justice Rodriguez's dissenting opinion, I'm sorry, from the fourth court. When you look, the possession of marijuana case was non-disclosed, and there was an order for that. And so we went to the expunction hearing. The government code in 411-076 lists the reasons that you can disclose this to the public. And it doesn't list that you can disclose it for expunction purposes. And DPS or the state wants you to believe that, well, it's okay because it's one criminal justice agency reporting to another. But if you look at 476, it lists the reasons you can non-disclose it. And it clearly says that a civil district court sitting in that capacity is not a criminal justice agency, as in subsection 7 of 476-011, because they make a distinction for name changes, where you can disclose it in the court for a name change.
Mr. Danford, going back to the other argument, I understand that the introductory sentence is offense-based. It's for the offense. But what do you do with the end of the sentence that says, provided that, colon, and then you get to the list, and one of the things in the list is capital A, which has to do with multiple offenses. What are we supposed to do with capital A?
Well, with capital A, again, Your Honor, I think if you apply just like you did in TSN and look at each offense separately, then there will be no confusion with this expunction statute ever again. All the courts would be clear on how to apply expunctions. So that I would ask you would separate each offense out individually. And if this person is entitled to an expunction, because they did ABC as the code provides, then you should be entitled to that. And on the other offense that's separated out, then you clearly wouldn't be. And then you get back again to the definition of criminal episode. Was it the same transaction, two or more transactions, a common scheme? Or then you look at, were they related offense? In our case, they weren't related offenses. And I don't believe they were part of the same arrest, because he was arrested initially for DWI. And then later on, they found the marijuana. And it's just like in some drug case, in some cases like this, where you're arrested for a DWI and they find a drug in the car. Well, you may not be arrested till later on, and they may file that charge at large because they have to send it to a lab and get results. And so I think you're going to have to take an offense-based approach in applying any part of the expunction chapter 55.
Any other questions? Thank you, Mr. Danford. We'll hear from the respondent.
May it please the court, Ms. Morrison will present argument for respondent.
Thank you, and may it please the court. Expunction is a statutory privilege, not a constitutional or a common law right. It was the legislature's prerogative to provide that privilege based on the plain language of 5501. As Justice Bland pointed out, 5501A2A has the provision that if there is a misdemeanor based on the same arrest as the offense that the petitioner is seeking to expunge, that offense must also meet the statutory reasons for expunction. Now, today, what we're discussing doesn't actually affect what the public sees, because neither one of petitioner's offenses are on his public criminal history record. Under Government Code 411-135A2, only a conviction or deferred that has not been non-disclosed is viewable on a public criminal history record. So what petitioner is trying to obtain today is the additional privilege of expunction so that licensing and regulatory agencies and law enforcement can't see the offenses that are hidden in his criminal history that are not for public view. But the plain language of 5501A2A is clear. And
let me ask you about that, Ms. Morrison, because it's A2A says that it has to be an indictment or information charging the person with the commission of a misdemeanor offense based on the person's arrest, or charging the person with the commission of a felony arising out of the same transaction. So this is a misdemeanor, not a, both charges were Class B misdemeanors, I believe. So we're not looking at the felony portion. So in what sense would you say that the marijuana misdemeanor was based on the person's arrest? And what does that mean in distinction from arising out of the same transaction? What's the difference between those two phrases?
Because they are both misdemeanors, we would look to misdemeanor based on the same arrest in this case. Now, he was arrested for DWI and they found marijuana in his vehicle. It's not in the record, but petitioner says it was part of an inventory search. And he does not dispute, in his brief, he says that he was arrested for both things at the same time. He was arrested for the DWI and the possession of marijuana. The informations on file show the same date of offense, and they were part and parcel. They would not have found the marijuana had they not pulled him over for DWI.
What if it had been several days before there was a determination that a white substance was cocaine, for example? Same outcome when you're seeking expunction, and they sent it to a lab and it came back, even 30 days later. Given the pandemic, it might take even 6 months. What then?
Yes, so typically when somebody is arrested, there would be one arrest. They would see that there's a white powdery substance. They would go ahead and charge the person with the offense. And then if the lab came back showing that it was drywall, then they would dismiss the offense or reject it, depending on what stage it is when the lab results came back. But those two offenses would still be based on the same arrest, or in that case, it would be a felony. If it was a felony possession, it would be arising from the same transaction because he was, driving while intoxicated while he had a white powdery substance on him.
But what's the difference between based on the person's arrest and arising out of the same transaction?
I'm sorry. So Once, so the misdemeanor based on the same arrest or felony arising out of the same transaction, that is the bar to 5501A2 being 100% offense-based, as the petitioner is trying to have you interpret it.
But what I'm asking though is what's the difference factually between an offense, setting aside misdemeanor or felony? The legislature obviously meant two different things here because it said it in two different ways. So what's the difference in the meaning between something being a charge being based on the person's arrest and a charge arising out of the same transaction?
Okay, I'm sorry, I was misunderstanding.
That's okay.
So that would be like a case of serial arson, perhaps. The transaction would be broader, or I would say like in Ryerson, the Ryerson case, which this court denied petition for review on, that was 5 burglary of a vehicle offenses where he just walked down a line of cars and smashed into each car on the way. And so that, although I think they were charged separately, the burglary of a vehicles those were, I believe, felonies arising from the same transaction. And but serial arson would probably be another good example because arson is definitely a felony. Now, the courts have found that A2 is either arrest-based entirely or that it's arrest-based with some restriction of them being related, the two or more offenses being related. None of the courts have found that A2 is entirely offense-based. This court in TSN left that interpretation open. While this court dealt with A1 and found that A1 was offense-based with the only bar being criminal episode, A2, there was no opinion expressed on A2. So that has been up to the different courts' interpretations. And the different courts have come up with different interpretations, but they all bar an expunction when there are related offenses, either based on the same arrest or the same criminal episode, same criminal conduct. They've found different reasons, but the criminal episode provision that petitioner relies upon only applies to A1. And that's pretty clear when you read subsection C, that only when there is an acquittal and a conviction out of the same criminal episode does it bar the expunction of an acquittal. And this court in TSN stated that 5501 is neither entirely arrest-based nor offense-based. So if A1 is offense-based, even if there's it's offense-based unless criminal episode applies, then A2 cannot be 100% offense-based because that would make the entirety of 5501 offense-based. And to interpret A2 as 100% offense-based would give dismissed and rejected charges a greater benefit than an acquitted charge, because there would be no bar to expunging a dismissed offense, even though it may have been pled to another offense, or there's a related offense out of the same arrest, such as here. This is the opportunity for this court, I believe, to give clarity to a body of law. The courts have interpreted many different ways, but we believe that the plain language is clear here and that the bar is set out not in a separate subsection like subsection C with acquittals, but under A2A, and that's the misdemeanor based on the same arrest language.
Can I ask you the same question I asked opposing counsel, which is, how does this work in reality when you have an arrest and multiple offenses arising from the arrest, and then only one offense is expunged? What actually happens to the paperwork?
So it's up to each agency on whether or not they would have to expunge it completely or redact it. Obviously offense reports can be redacted, videos can be redacted. The court didn't agree with when we made this argument in TSN about, the kind of not impossibilities, but the practical considerations of it's difficult to redact. The court didn't follow that logic in TSN when it came to acquittals and said that, we could redact, and we have been since that case came out. I know that, offense reports have been redacted to remove the acquitted offense when there's something else like in TSN where it was a warrant out of the, an outstanding warrant that they were arrested for something else. I hope that answers the question.
It does. Thank you.
So it's not hard to do, but it's not consistent between the agencies. This court, and I do want to get to Mr. Danford's non-disclosure argument as well, just because he did reach it in the end, but it was a majority of his petition for review.
But before you get to that, Ms. Morrison, what effect do you suggest that the amendment of A2 had, changing from any offense to the offense? Does that just not make any difference given the language of A in your view?
That's correct. And actually,
so if that's true, why did the legislature make that change?
Because prior to that, no other offense could have served deferred at all. So, right. So I'm sorry. No other offense could have been expunged if you served any deferred adjudication at all, I believe. And then in 2015, the legislature attempted to make 5501 100% offense-based. And Governor Abbott vetoed that because he found that it went too far. He did not veto it because it was already offense-based. The courts have pretty steadfastly held that it is not 100% offense-based. So they knew how to make the statute offense-based 100%, and they attempted to do that, but it was vetoed. And since—
What year was it vetoed? I'm sorry, I missed that. What year?
2015.
Okay, thank you.
And since then, in 2017, non-disclosures have been greatly expanded, and DWI convictions can even be non-disclosed. So rather than add additional statutory privileges to the expunction statute, they have added to the non-disclosure statute. And that, like I had said before, allows for offenses to be hidden from public view, which is the majority. So if the petitioner here walked into Walmart and tried to get a job, they would not be able to see either one of these offenses because neither one is on his public criminal history. And if anybody doesn't have any other questions, the non-disclosure issue, there are 4 ways that those non-disclosed documents could be used in an expunction hearing and were used in this specific case. 2 of those are statutory and 2 of those are just factual. So petitioner argued the exceptions to 411-0765. And he stated that a criminal justice agency has to disclose it to another criminal justice agency, but that is a misreading of the statute. 411-0765A2 is a standalone provision. A criminal justice agency, in this case DPS, can disclose non-disclosed criminal history record information for a criminal justice purpose. Here, the criminal justice purpose was the administration of criminal justice or the storage, access, and dissemination of criminal history record information. Now, that is one of the reasons. Now, the name change provision that he cited in B7 is a separate listed event for when criminal history record information is being disclosed to a non-criminal justice agency. A district court serving in a name change capacity is not a criminal justice purpose. This, in expunction, is a criminal justice purpose. The other way is that this court in In Re State Bar on page 625 said that somebody can, in effect, unexpunge a previously expunged record by putting it into issue in another proceeding. That would be the same for a non-disclosed record. And here, the petitioner clearly put the records of his arrest in issue during the expunction proceeding. So he himself opened the door to the non-disclosed records. The other issue would be that the judge who granted the non-disclosure although the non-disclosure was granted in a district court when it should have been granted in a county court, the judge who proceeded over the expunction hearing had actual knowledge of the non-disclosed offense because he himself signed the non-disclosure. And the record reflects that he was the first one to bring up the non-disclosed offense at the hearing. Now, whether that was because of actual knowledge or because of the answer that DPS filed, it's unclear, but it just goes to show you cannot expunge a memory, just like you cannot seal a memory. The judge may have had a memory because he signed the non-disclosure a few months prior. And so his actual knowledge could be brought into the hearing, that this possession of marijuana existed. And that court found that under Ryerson, because A2A shows that it is arrest-based statute, that because he had a deferred adjudication out of the same arrest, he was not entitled to an expunction of his DWI, despite having completed a pretrial diversion agreement. And then the other factual issue is that the records were disclosed to the court in the department's answer that was filed prior to the non-disclosure being filed. So the expunction was pending. The petitioner realized, that he saw our answer. He saw that it was arrest-based, that the offense, that he couldn't expunge both offenses or even one offense. And so he went and obtained a non-disclosure in order to circumvent the requirements of the expunction statute. And the Fourth Court of Appeals was clear that a non-disclosure cannot be used to circumvent the requirements of the expunction statute. And if A2 is 100% offense-based, the way the petitioner argues, then he would have had no need to get a non-disclosure on that offense during the expunction proceeding. So that argument also fails.
Ms. Morrison, back to the first issue. Do you think the 14th Court of Appeals decision and MBJ in 2018 is just wrong?
I do not. That court actually came out with an opinion after MBJ called Ex Parte Brown, where they clarified that related offenses cannot be expunged if one resulted in a deferred.
And related meaning
so
what in this,
So the 14th Court of Appeals said related. Several of the courts have come up with different versions on what that means. So the 8th Court of Appeals talks about plea bargains, whether or not they were dealt with as part of the same plea bargain. The 2nd Court of Appeals has talked about a single instance of criminal conduct. The 8th Court of Appeals has also talked about same transaction. It really depends on even the panel of this different courts, because some courts have come up with different reasonings just based on which justices were seeing the case. Some talked about criminal episode, which is maybe why petitioner is confused to think that criminal episode applies here, even though it's not an acquittal scenario under A1, and C, criminal episode only applies to A1.
It seems that perhaps the appropriate connection to look for would be that the other offense was based on the person's arrest, as A2A says. Would that be your recommendation?
Yes, Justice Blacklock, that is exactly what we are asking this court to do, is to look at the plain language of 5501A2A when making that decision of whether or not related offenses can be expunged. Our argument is that if they are related and one resulted in either conviction or deferred, or just wasn't dismissed for one of the statutorily specified reasons and is ineligible for expunction, then both of the related charges are ineligible for expunction. As far as policy arguments, now petitioner here still received the benefit of his bargain. The purpose of his pretrial diversion agreement was to avoid prosecution, which he did, and his case was dismissed. Now, at the time he pled, a pretrial diversion was the only way to have his DWI dismissed and for it not to affect his public criminal history record. So he does not have the same collateral consequences as he would if he had a DWI conviction. He didn't suffer a license suspension or surcharges under the prior surcharge program. It's still dismissed. It's not public. He could apply to an outside job that doesn't require a special license, and they would not be able to see it. Since then, the legislature has expanded the ability to obtain non-disclosure even for DWI offenses. So if this was his first time DWI, he would potentially be eligible for a non-disclosure even if it had resulted in a conviction. The other hypothetical I would like to bring up is that because now DWI convictions can be non-disclosed, this may, to interpret the government code to allow non-disclosed records to be admitted, would potentially throw a kink into the A1 criminal episode provision, because you could get a DWI conviction non-disclosed and then have something else out of the criminal episode, and the court would not be able to see it. So when considering the non-disclosure argument, we would just ask you to consider that it may conflict with 5501C when it comes to criminal episode. And I can see I'm running out of time. Does anybody have any more questions?
Any other questions? Thank you, Ms. Morrison.
Thank you.
Mr. Danford, I believe you have 5 minutes.
Thank you, Your Honor. We're just asking for not an absurd result. And what I mean by that is this. With this expunction, he got a non-disclosure on a possession of marijuana charge, which was a result of a deferred adjudication. But when you have a pretrial diversion, which the code says you're clearly able to get an expunction, he's now not able to get it if we don't take this approach. And I just don't think that's what the legislature intended, because you didn't get the benefit of your bargain, because it says when you have a pretrial diversion, you're entitled to an expunction in the code. But now he's not able to because of the marijuana charge. That's why we ask you to take the offense-based approach. If you look at DPS's argument, especially with the drywall case, where they found the white powder in the car, they sent it off to the lab, and it comes back as, like she said, drywall. Well, in that case, he would never be able to get an expunction on the drywall part if you adopt her position that she's asking you to take today. We're just actually asking the court to clarify for all the courts how expunctions work and make a clear language to the courts, because they're all over the place. The courts of appeals are interpreting this in many different ways, even after TSN. And we just ask you to adopt the same reasoning you adopt in TSN and apply it to A2. We would again argue to the court that these charges were not related. A DWI and possession of marijuana are not the same charge. They're not lesser included offenses of one or the other. And I don't believe they were the same transaction, because if you look at transaction, he was clearly arrested for a DWI.
I think what we've zeroed in on that is that because it's not a felony, the same transaction language doesn't apply. But what's your response to Ms. Morrison's argument that that the marijuana charge was based on the same arrest?
Well, I guess it defined your definition of arrest, but he was arrested for the offense of DWI. And then subsequently, he was arrested for the offense of possession of marijuana.
Do we know in the record that he was arrested for the possession of marijuana, or was he just charged with that?
He was
after he had been arrested. The language of the statute is based on the person's arrest. So what I'm trying to figure out is, how do you interpret that?
Well, my interpretation was that he was arrested for the DWI. Then subsequent to that, we was at the police station and they were doing the inventory. They found marijuana. And yes, I would charged, arrested, I think, or can be read together, but he was charged with the possession of marijuana later on. But again, I think for clarity for the appellate courts of this state and for the citizens of the state of Texas, that we need this court to adopt that just because there's two separate offenses, especially with that drywall thing, in her positioning, you would never be able to expunge that because they happened out of the same criminal episode. He was convicted for the DWI, yet the drywall stuff turned out to be drywall and not an illegal substance. So we're just asking for clarity. And I think if you don't clarify this the way we're asking, then we're going to be back here again before the court with more cases. and we're going to be having these absurd results where you got the pretrial diversion and you can't get an expunction because of this non-disclosure that wasn't supposed to be disclosed anyway. But I don't have anything further to add to the court. If there's any questions, I'd be glad to entertain those.
Any other questions? Thank you, Mr. Danford.
Thank you for your time. I appreciate it.
The case is submitted and the court will take a brief recess.
Guess we're free to go.
Hold on just a second.
All right.